Good morning, good afternoon, good evening, depending on your time zone. Thank you very much for joining us during the 2024 Climate Law and Governance Day, and welcome to this legal roundtable, galvanizing global attention on the International Court of Justice climate change proceedings. We're delighted to have you here with us. It is now my pleasure to pass this over to the chair, Advocate Mert Kumru, the European Front Coordinator for the World's Youth for Climate Justice, who is a passionate advocate for climate justice. He was a UN youth representative and currently works for several organizations within the Netherlands and across Europe, campaigning and working towards the ICJ climate change opinions. Mert, over to you.
And I think now you should hear me. Good morning. Thank you so much, Neshan, for handing over the introduction. And I'm very pleased to be here today. We have an amazing panel of speakers, so I hope you're all hyped, just as I am. We will have time for questions at the end as well. So it will also be an interactive session. So please, if there's anything that pops up during the session, do not hesitate to write it down. And afterwards, later on, we can provide you with some insights. Is anything else unclear for now, or is it all good? Perfect, amazing. Then I think it's good to ask our amazing panelists to briefly introduce themselves. And looking at my screen, I see that we could start from the left top corner. So I would love to give the floor to Nala Nassar. Nala, could you perhaps introduce yourself briefly?
Good morning, everyone. It's lovely to be here with you today, this day, and I'm the moderator for this session, and I'm looking forward to hearing all about today's session. Enjoy, everyone. And going back to Mert.
Thank you, Nala. Then I'd like to give the floor to Siwa.
Thank you very much, Mert. Good morning, good evening, good afternoon, everyone. My name is Siosiua Veikune, or Joie. I'm with Pacific Island Students Fighting Climate Change as the Tonga-based campaigner. And yeah, I'm happy to be on the panel. Thank you again to the facilitators of today's program. Yeah, looking forward to the discussions. Back to you, Mert.
Thank you, Siwa, and a very early morning for you, I reckon. Then Samira.
Hello, everyone. My name is Samira Benali. I'm a campaigner from the island of Mayotte, France, and I am the Outreach and Engagement Coordinator of the World Youth for Climate Justice. It's a pleasure to be here with you for this day. And yeah, back to you, Mert.
Thank you, Samira. Joie?
Hi, everyone. I'm Joie Chowdhury, a senior attorney, climate litigation and accountability at the Center for International Environmental Law. Very happy to be here. Back to you.
Thank you, Joey. It's also very fun for all of the attendants to understand that all of these people are either way connected with one of us or more people. So it's all kind of a friends coming together. Then last but certainly not least, Leisl.
Hey, I'm Leisl Muller, and I am representing the Youth Climate Action Project at the University College Cork, doing research about youth activism. And yeah, very happy to be here. Thank you for having me.
And I absolutely, I mean, I'm almost ashamed that I forgot to ask Neshan to also introduce himself. So Neshan, obviously also the floor to you.
Thank you, Mert. Never forgotten. Such a pleasure to see everybody. Good morning. I'm Neshan Gunasekera. I'm a lawyer from Sri Lanka, currently lead counsel with the Center for International Sustainable Development Law, but also visiting researcher at the Raoul Wallenberg Institute here in Sweden, and also counsel of the World Future Council. Looking forward to our dialogue. Over to you, Mert.
Amazing. Thank you so much. This dialogue is also taking place in a very interesting context. COP29 is taking place, and as we speak right now, 72,000 attendees are making the best or trying to make the best out of this COP conference. And I'm very interested in hearing some more from our panelists about the entirety of this framework in which we're operating and in which we find ourselves. I would like to kick it off with Joie. and ask Joie what the significance is of addressing climate justice through a legal avenue, such as the advisory opinion at the International Court of Justice. And in particularly, we're talking about the advisory opinion on climate change, obviously. So Joie, I would like to give the floor to you.
Thank you, Mert. I guess what is perhaps most striking about the escalating global climate crisis is not just its increasingly severe and devastating impacts on individuals, peoples, ecosystems, and states, inflicting damage through sudden and slow onset events alike, nor is it just the fact that those events are hitting those in situations of structural vulnerability the hardest, compounding inequalities, entrenching impoverishment, and undermining human rights. It is the fact that the world knows and has known for decades what is causing the crisis and the consequent devastating harm, and yet those most responsible have failed to act with the urgency and decisiveness required to address the crisis at scale and provide remedy for those on the front lines of climate harm. Avenues such as the ICJ Climate Advisory Opinion, which can draw on all relevant sources of international law and which has seen unprecedented participation from states facing severe climate impacts, has the opportunity to elucidate states' obligations in relation to climate change and unlock action needed not only to prevent continuing harms, but in line with existing obligations, remedy those injuries that have fallen and are falling and will foreseeably continue to fall disproportionately on those least responsible for the planetary emergency. An ambitious opinion of the court could deliver the compass that we need to navigate a safe and just future for our communities by finally holding polluters accountable. And accountability is central to climate justice. Just the madness of continuing to harm and refusing to repair must end. And a starting point for that can be legal clarity, guiding future climate cases and climate action. And also, just to end in terms of significance, advisory opinions are an efficient, legitimate, non-litigious and authoritative interpretation of binding law to provide states clarity on their international legal obligations with regard to climate change. This opinion will likely serve as a vital precedent, providing guidance for climate change cases across jurisdictions, and may help cut through the political inertia that we are seeing that have plagued climate negotiations. Mert, you're at COP29 right now, and that have also plagued national level climate action. Unlike often closed door negotiations, what we will see in December right now during the public hearings is an airing of government positions on key legal questions. And this provides an important foundation also to campaigners for accountability. And finally, the proceedings also allow for strategic mobilization towards shaping the narrative around climate change, building political power, and creating a foundational basis for campaigns and legal cases to advance much needed systemic change. So I'll leave it here, Mert, back to you.
Thank you, Joie. And I think it's very important to also highlight that importance, and indeed, especially coming from your background at CISDL, I think we see a lot of people right now here at COP also feeling this sort of distrust in the system, or at least less trust in the system. And I think it's up to us as advocates in this field as well to gain that trust from the general public to build further upon. Thank you so much, Joie. And I think a lot of people would love to also see the significance more being more central as a question. So there probably will be some questions for you as well later on. I would like to continue to Neshan. Neshan, your question that I'd like to ask you is, what significance does the ICJ on climate change have for the furtherance of international law, including intergenerational equity and trusteeship? And perhaps it's good to maybe also explain what international equity and trusteeship means, because I'm not sure if everybody is on the same level as, for example, you. Thank you so much.
Thank you, Mert. I mean, a great pleasure to follow the powerful words of Joie. I fully agree and endorse what she said. And again, thanking Samira and the World Youth for Climate Justice and the Pacific Youth for the invitation. To combine that question, Mert, with the topic today, kind of gaining global attention, let me start by saying the ICJ advisory opinion on climate change is the most important case of the 21st century, and not just for the International Court of Justice, but for whole planet Earth. And I would like to coin this, given the magnanimous opportunity that it brings, within the moment. I think we really need to capture the imagination. And here I'm going to borrow a word from our wonderful young people from the Pacific Islands who's inspired this. The word is waka, which I believe stands for a voyaging canoe, which we are all now part of, thanks to the inspiration that they bring. And this waka has traveled from the Pacific Islands across the world, gaining the championing of the World Youth for Climate Justice and others, to New York, where every single member of the United Nations have signed on to the resolution that put the question before the International Court of Justice. So I think that's the first beginning, I would have said, the evolutionary chapter of international law for the 21st century that the WACA has brought us together. And to capture the moment, I would like to coin it between courage and inspiration that links for international law. And here, the work of the Pacific Island students, the World Youth for Climate Justice, and the numerous champions of this who are on this call and those who are not on this call, but here represented through Spirit, are looking at expanding the implications of international law for the 21st century. And Joie very correctly talked about accountability. And this is where the 21st century international law evolves, and a strong advisory opinion bringing up to the implementation is absolutely key in taking this forward. And here I must mention the pioneering work and courage and inspiration that Judge Christopher Veeramantri, former Vice President of the International Court of Justice and founding counselor of the World Future Council and Right Livelihood Laureate, brings to this. And that's where I will answer the question on trusteeship and on the question of intergenerational equity. Two quick cases of almost a generation ago, 27 years ago, he gave a fantastic dissenting opinion on possibly the most important case to go before the ICJ last century, which was the legality of the threat or use of nuclear weapons, where he categorically stated that nuclear weapons were not only a threat to current generation, for generations yet to come, and bringing in the future generations dimension, which is an aspect that has been put to this court for the first time. And another case, which is the Gabčíkova-Nagymoroz project case, a case between Hungary and Slovakia, Judge Veeramantri wrote a fantastic separate opinion where he announced the principles of trusteeship as the first international environmental law principle. Now that's spearheaded a fantastic momentum today where we're developing something called the Earth trusteeship principles and inspired by him. Quickly to say, intergenerational equity looks at our relationship within each other, but also future generations. Whereas trusteeship widely looks at that we do not own anything in the natural environment, that we hold them in trust for those who here are now and those who are yet to come. I will leave it at that and come back later. Thank you, Mert. Over.
Thank you so much, Neshan. And it's always very wonderful to see someone besides yourself saying that this is the most important climate case in our century. So very happy that you repeated that as well in this context. But also referring to Judge Veeramantri, I think especially in our field of law, in international law, his dissenting opinion is like a sort of a rock star status almost. We like to refer to it also as WYCJ and PISFCC because it explains how important this concept is of climate change within the international law realm. And I think, and I hope, and that's our expectation as well, that with this advisory opinion, we can set a new standard internationally to generations to come to build on international climate policy and international law. So thank you so much, Neshan, and I think also applauding you for the amazing work that you do on this as well. Then over to Siosiua Veikune. Siosiua, I mean, we know each other for quite some years now, and we've worked on amazing things. You're now in the Netherlands already preparing for the oral hearings, so you're already adjusting to the time zone. But I'm wondering, Siosiua, you were part of the ICJO campaign from the very beginning. And for those in the room who do not know the background of the ICJ advisory opinion on climate change, could you tell us maybe a little bit more about the background of it? And can you also tell us about the story, how it came to be? Over to you, Siosiua.
Thank you very much, Mert. Yeah, the personal opinion, we've told this origin story so many times, and that's only because it's an origin that we're very proud of. That's the truth of it. But yeah, definitely for those on the call that aren't aware yet of the campaign and its origins, the ICJO campaign, as we dramatically like to put it, was birthed on Pacific shores. And back in 2019, in a classroom in Vanuatu, where the University of the South Pacific has its main law campus. It will get a bit repetitive for those who've heard this a bunch of times, but it was initiated by 27 law students who were essentially given an assignment question being, how do you address climate change in an alternative route of international law that isn't Paris Agreement or UNFCCC? And the answer that they came up with was requesting an advisory opinion from the International Court of Justice on climate change and human rights. Oh, that's a mouthful. But that was the answer that they came up with. And being the stubborn optimists that they were, they took it beyond just an assignment and took it outside of the classroom, something that was thought of, they chose not to leave it as a simple thought experiment in the classroom, but attempted to execute it in the real world. And of course, you fast forward a few years to March of last year, and we find ourselves having attained that unanimous adoption in the but we today are able to travel the world, meet amazing people, work alongside these even more amazing minds in the legal space and beyond. Because of those initial ambitious and stubborn optimists at the beginning. I think, and Neshan, you mentioned earlier about how that approach of the WACA, and that perfectly sums up what this journey is to everyone. It's providing space for like-minded individuals who are willing to go beyond the standard of performance that the climate space has been used to, and taking it that extra mile. I think something that also is worth commending is the relationship that Vanuatu has allowed between government and civil society. I think more than anything, this campaign has shown exactly what is attainable when governments and civil society have a shared cause, a shared goal, and is willing to give each other space to collaborate and effectively deliver on anything and everything, essentially. So I know this is sort of jumped away from the origin story, but I mentioned those core values because it's something that has been there from the very beginning. It's always been intergenerational equity and the collaboration between generations, as well as human rights. Because at the end of the day, a human rights approach to this is essentially bringing people to the core of the solution, and that's been the goal since day one. It's bringing voices that are often neglected or shunned in these spaces and allowing them to be heard and being more than just an active voice, but active hands in contributing to a solution to the climate crisis. I will pause there so as I don't go beyond the confines of the question. Back to you, Mert.
Thank you so much, Siwa. And I think repeating the origin story of this campaign is also very important to explain how this is youth-led and how it is youth, especially from the Pacific, from the Global South, that are not only standing at the forefronts of the climate crisis, but also at the forefronts at the court in The Hague. So I think that's something that we should always keep on telling for generations to come. Thank you, Siwa. And thank you for the Pacific Island students fighting climate change for being such trailblazers in this regard. We're ever in your debt when it comes to this. Then I'd like to continue to ask Samira Ben Ali from the World Sea for Climate Justice on how this opinion could strengthen the youth's response to climate change. And I think that's also very interesting in the context of proceedings beyond the court. So Samira, over to you.
Thank you, Mert. And just to come to Siwa's remark at the beginning, it's never get boring to hear this origin story. I heard it millions of times, I think, at this time, but it's always still so good to hear. So no, thank you for reminding us about it again. And to come back on the question on how this opinion can strengthen the youth response to climate change, I think it's interesting first to come back on the question that have been asked by this opinion. But the first question focused more on the legal obligations of states in regards to the climate change. And the second question goes to the legal consequences, not only towards future small island states that have been affected by climate change, but also on future generations. And this is a really interesting turn of the question, because this second question needs to be approached through the principle of intergenerational equity. Neshan has already reminded us a little bit of the concept behind this, intergenerational equity, and basically that is saying that the earth is a shared inheritance, that the resources that we have right now are, of course, ours to use, but also there are also future generations to use. So we must make sure, as present generation, to leave the earth as we found it, not in a worse condition for those to come. So by approaching the second question, and if the court does so, by approaching this second question through the lens of intergenerational equity, it will, for the first time, actually give more of a legal status to this principle, because even if it has been recognized and mentioned in several international conventions and several international treaties, there is no real legal instrument at this level that has done the work of defining it thoroughly. So by making sure that this concept is defined, that it is well framed, it could give power to youth to use it later on in their advocacy and also for policymaking and litigation, especially because this principle rightly framed the failure to act against climate change as a violation of the needs, the rights, and interests of young people and future generations. So by trying to frame this principle, the court will give an opportunity to youth to make it clear that future generation need to be considered, and young people are the closest to future generation. And they can then use this at all level, international level, as we are doing right now, at regional level, national level, and particularly here at COP. I think that for young people who are, for example, part of constituency like Yongo, they could use this advisory opinion and what it says for young people to try to push for measures around mitigation, adaptation, and for example, also reparation, because Joie and I actually were in a debate last night around those notions, and this could be a powerful legal tool to try to make sure that young people that have been harmed by the consequences of climate change are able to advocate for themselves. So yeah, I'll leave it at that, but I think that it has a lot of potential depending on how the judges decide to go with this.
Thank you, Samira. And I think it's also always very good to explain to people that the outcomes of the advisory opinion are absolutely important, but having the best positive outcome doesn't necessarily mean that all judges are all in agreement. I mean, obviously that would be the most ideal thing, but even if there's a dissenting opinion, even if there's some dissent within the court, it still is very important and still is very good, especially also looking at the wide array of states that are participating. We see oil states, we see a climate justice states, so to say, to quote them. So it's a very wide array and also very broad recognition. And I think that broad recognition is also very important for the actual significance of the advisory opinion. Thank you, Samira, on clarifying this. Then I would like to go to Leisl. And Leisl, the question that I have for you is, in what ways could the advisory opinion potentially influence international law's approach to recognizing and empowering children, specifically as leaders in climate action?
Well, thank you very much. I'm representing today the Youth Climate Action Research Project funded by the ERC and hosted at the University College Cork. But it is a very global project where we are researching child activism, child and youth activism, and litigation, specifically globally. And we have set up a database of case law, and we are looking at cases right across the world, taking from how the law is developing. And the interesting part of that is that youth and children are acting as leaders, not only in the campaign, but in developing the law, which is fantastic. And so we find that, I mean, it's really unfortunate that children can't and young people can't directly engage with the court, and that governments haven't properly engaged with young people and children before making their submissions. That would have been ideal. And what is coming out of the case law is that children are pushing their right to participation, which is really amazing. But the advisory opinion, of course, if it contains good guidance on legal principles that are still up in the air, legal definitions around future generations, intergenerational equity, if this advisory opinion can clarify that and hopefully also recognize the agency and autonomy and leadership of children and young people in the fight, that would really be empowering and very important, I would say.
Thank you so much, Leisl. It's also always very comfortable for a chair of a session when everybody keeps such well their own personal statements, so the time is perfectly in order. So we actually have time left even for this first round, which doesn't mean that we will waste that, because in the second round we obviously have more questions for our panelists, and I already see that people are writing down some questions for the Q&A later on. So Nala will definitely keep eye on that. I would like to come back to Joie. And Joie, I'm wondering, what legal issues do you consider are more contentious in the ICJ proceedings, and what will become a more ideal outcome regarding these issues? Maybe also explain what a contentious case exactly is for those of us that do not know.
Sure, Mert. I will take that very complex question and answer it in 3 minutes. No, but I will do my best. Well, I think the issues that you consider most contentious is basically the issues that there is the most kind of divergence of views, shall we say, among states. I mean, there's contentious cases where courts come in and they settle a dispute. An advisory opinion is different than that. In an advisory opinion, it's the clarification of international law, so it's different in that case. So since time is short, I'll mention just 2 issues. And before that, I'm going to just spend one line. And for those of you who follow the legal side very carefully, I apologize, because this is a huge simplification of the questions. But essentially, the 2 questions posed to the court are: what are the legal obligations of states in relation to climate change? And if those legal obligations are breached, what are the legal consequences? And they're deceptively simple sounding. They are very, very complex, and they're the heart of some of the most difficult legal debates around climate change. And the most contentious issues are actually rooted in these 2 questions. So one of the key contentious issues in relation to defining the scope and content of state obligations in relation to climate change is the issue of applicable law. Whether the climate agreements, including the Paris Agreement and the United Nations Framework Convention on Climate Change, the UNFCCC, exclusively guide the interpretation of state duties in the climate context, or rather, multiple sources of international law define and inform the scope of state duties in relation to climate change. And on this, as multiple authoritative sources have affirmed, the answer to the climate questions before international tribunals neither starts nor ends with the UNFCCC and the Paris Agreement. Now, these treaties are very relevant to the questions before the court, but their limited scope does not allow them to fully answer those questions. And despite our arguments to the contrary by states, and we've seen these arguments play out before the other international tribunals, right? Because Now the International Tribunal for the Law of the Sea has issued a climate advisory opinion. The Inter-American Court of Human Rights is considering one. So we see some of these arguments having already played out before the court. And so we've seen states and scholars argue that it really is kind of rooted in the climate treaties. But we've also seen strong arguments against that, yes, these are relevant, but states have obligations under multiple existing sources of law, including the law of state responsibility, customary and conventional international environmental and human rights law, and the law of the sea to act in the face of the climate emergency to prevent further foreseeable harm from climate change and to remedy harm that has already occurred and is occurring as a result of climate change. Climate change is not just an environmental problem. It has cross-cutting effect on society in all areas of law, and no one legal source under Article 38(1) of the ICJ statute can fully respond to the complex interlocking dimensions of climate change and the myriad of ways in which climate change affects public and planetary well-being. And relevant here, I've already mentioned the Int'l, the International Tribunal for the Law of the Sea climate advisory opinion, but just to say again, this has now affirmed very clearly that states do not meet their international legal obligations related to climate change simply by fulfilling their the obligations contained in the Paris Agreement. Thus, ideally, in answering the questions posed before it, the ICJ would clarify that states have concurrent obligations under multiple existing sources of law, and such obligations must be interpreted harmoniously. So I'm sorry, Mert, I'm going to just take one more minute to wrap up. Another primary contentious area is, and I'm sorry, this is gonna be a legal, I'm happy to answer questions afterwards, but we're asking what is the law that applies? And then what happens if this law is breached? And at the heart of these two questions is what is the relevant conduct at stake underpinning these two questions? What constitutes unlawful conduct that triggers legal consequences? And along the way, legal questions, there are many legal questions that can arise in relation, for example, to temporality or causality, and these can be countered effectively, but it is not always settled law necessarily. So this is where I imagine that we will see a divergence of perspectives from major polluters and states most affected by climate change. And ideally, the ICJ will clarify that the relevant conduct comprises of the acts and emissions of states or groups of states alone and in combination have over time generated cumulative emissions that cause significant harm to the climate system and other parts of the environment with respect to states, including small island developing states, and peoples and individuals of the present and future generations. And that in the face of unequivocal science and the long-standing knowledge about the causes and foreseeable consequences of climate change, that such conduct breaches a variety of state obligations under international law, triggering legal consequences in the form of duties to cease wrongful conduct and provide full reparation of resulted injuries. So I'll hand it back over to you now, Mert.
Thank you so much, Joie. And since I'm in a generous mood, I would like to tell to all panelists, you can have all an extra minute to provide your answers since you were so quickly in the previous round. Thank you, Joie, for the amazing answer. And also, I think it's very important to dive a bit more deeper into that and also explain a bit more carefully what it exactly means. And I think that's needed for the attendees to also take into their to their own consideration later on. Neshan, I would like to ask you, how can the ICJ best contribute in clarifying the human rights standards applicable to climate change? And I think that's something also very important, right? The clarification of human rights standards. Could you please elaborate on that?
Thank you, Mert. I think I'll bring the Joie caveat to this as well, that itself is also quite a complex arena. But let's backtrack to the UNGA resolution that actually put the question. So it talks about international obligation of states with regard to protecting the climate system and the wider environment. And it says, the parts of the environment. I think Joie really, constructed arguments for the climate system, but the human rights application to the wider environment is another aspect that the ICJ needs to go in. And that's why it really then expands. And the ICJ, apart from looking at the 30+ multilateral environmental agreements, and its interpretation through General Comment 36, which talks about right to life and is linked to climate change, it really needs to look at how the climate sphere connects to the biosphere. And that's where the human rights discussion is absolutely critical in expanding what we state that the evolution of international law for the 21st century. And let's quickly, look at two, historical things. I mean, Joie mentioned the Int'l advisory opinion, which came out in May, and I think most of us, Samira and Naima from courses, we were there in Hamburg. And one of the key things that Int'l specified was the evidence of the science through the IPCC. It confirmed that the science is here. It has been around, of course, as we know, for decades, but it was the Int'l's advisory opinion that confirmed the IPCC evidence. And that's another aspect of human rights, right to the sciences, that the ICJ will also need to expand upon, looking at the wider application of the Bill of Rights. And a second point is, in July, we celebrated 125 years since the first Hague Peace Conference, which set in motion various events that led to the Permanent Court of Arbitration being established, League of Nations at the Permanent Court of International Justice, and the ICJ under the United Nations. Now, when ICJ was born in 1946, taking forward the jurisprudence of the PCIJ, there started the human rights discussion too. And we should not forget that the ICJ and the human rights discussion went hand in hand. And come to 2024, ICJ, as Joie and others mentioned, doesn't function alone. It functions in this institutional framework of international judicial architecture, which has a complementarity role to what's going on at the regional level, and over the almost 3,000 cases going on at the domestic level. And here we need to bring in the human rights application. I really like the way Suya mentioned this, and Leisl, about having wider people participating in this process. I know it's 2 weeks to go. 98 countries are going to be going before the ICJ. Children are not represented. Indigenous people are not properly represented yet. And we're really unpacking the evidence of customary principles of international law, as well illustrated by Judge Veeramantri's jurisprudence in the court, quarter of a century ago. We need to make sure that these voices are included and that evidence is brought before court directly. And just an anecdote, in the nuclear weapons case, what moved the 15 judges of the court was the story of a woman from the Marshall Islands talking about trying to have a baby in a situation where the atmosphere was filled with radioactivity. That moved the court. The story of young people from the Pacific Islands coming on the WACA needs to be put forward as a human rights story to the court, so that the judges can look at it as evidence. And this is where the imagination really needs to be captured. Whilst we have the treaties, we have the Bill of Rights, and it's a unique opportunity for the ICJ to interpret this. It is up to the wider people to bring these stories as evidence. That's where I believe the customary principles of international law will get strengthened. So the treaty interpretation, again, we look at customs in that, the treaty interpretation will be further strengthened. So again, to recap, the science was confirmed in the Int'l's advisory opinion. And the human rights framework will be first looked into in this situation. And with regard to the biosphere, there is the World Charter for Nature from 1982 that looked at equating what's going on in the human rights world beyond the Anthropocene. And then we have developments across the board on these things, moving into crimes against the environment, the ecocide movement, the Maastricht principles of human rights of future generations, and various other developments that I believe can strengthen the opportunity the 15 judges have. I'll end it there. Thank you.
Thank you so much, Neshan. I think this is also, this touches upon a very important topic, that the judges of the ICJ do not live or operate in a vacuum. They are very much aware of all of the things that are taking place outside of the court, before the court hearings take place and after the court hearings take place. And especially The Hague is a small city compared to major metropoles. So you will bump into these judges at your local gym or at your local supermarket. So these things are seen and these things are felt. And I feel like it is super important to reiterate that gaining public attention and galvanizing the public influence in these cases is something that the Pacific Island students and WYCJ have worked on for years now, and we hope that it all will culminate into something amazing taking place during the hearings in The Hague in a couple of weeks. It feels almost scary to say in a couple of weeks. Siwa, I would love to ask you, when we talk about the hearings, what exactly is the role of small island states, and also often used term is SIDS, small island developing states, but especially in the Pacific, and those that are championing for calls for a human rights-based approach to climate justice? Over to you.
Thank you very much, Mert. Yeah, it's a really tough crowd to follow, Neshan and Joie. But and I've spoken about it previously as well. As you've already heard, that there is, for us in the Pacific, climate change is not a distant threat, as some may say. It's reshaping lives at this very moment, and our communities face disruptive change at a rate and scale that generations before us are just completely unfamiliar to. And it's important to mention that we're not here to not only talk about the fear of that loss, but we're here to talk about how we can protect what remains and what we can build if efforts are made together. And these oceans that we claim as our homes is something we intend to defend our right to thrive in it. And the Pacific being the home for several frontline communities, it holds that moral voice of this matter, as well as the advocate for the future. And what I mean by that is moral voice in the sense that the Pacific's culture is rooted in its nature. Without it, it becomes null and void. So the Pacific's culture is rooted in nature, and there's a responsibility to protect its environment that the Pacific people have possessed for generations. It's existed long before us. And that's a responsibility that's merged and solidified within our DNA. But also advocates for the future in the sense that frontline communities act as a window for the rest of the world to see just how bad the climate crisis can become for more fortunate communities. And the human rights-based approach, as I mentioned earlier, was the attempt to bring people to the core of the solution. And again, we find ourselves at that conclusion that the climate crisis is a human rights crisis. So that responsibility is the attempt to look beyond ourselves and beyond this movement, and it calls on the court and all countries to uphold a standard of justice that stretches far into the future, so that those yet to be born can inherit a world in which they can thrive and not just struggle, not just struggle to thrive, but to be able to survive it. And this legal process is about accountability, is similar to what Joe and Neshan mentioned earlier. It's about accountability in this shared humanity. And it's a call for every nation, no matter its size, of course. From the small island states, there's a big push, but no matter the size, it's a call for these nations to take responsibility for the future that will be shared, but also inherited by our future generations. And in the end, small island states are here because there's a belief in a world where every voice matters, and where every action counts, and where every generation has the right to thrive. The advisory opinion request is a chance to move closer to that vision, and we build this future together, no matter how long it takes. It really is that. It's this or nothing else. I think that approach has been cemented to this movement from the very beginning. There was no plan B to this. We take this forward any means necessary, and that's not to get too radical on everyone, but that has been the approach. And I think the success and the countless milestones, not just PISFCC, but every single organization that has been a part of this, the countless milestones that we've been able to attain, is a testament to that shared goal of being able to not just survive this climate crisis, but to thrive in it. So at the risk of crying myself, I'll get back to you, Mert.
Thank you, Siwa. And yeah, I think it's wonderful to also highlight that, right? It's not survival that we're only seeking, it's also a thriving future that we're seeking. And I think that nuance is very often forgotten in the context of the climate crisis, where survival is our right indeed, but thriving is also a right for everyone. And the enjoyment of human rights is something that shouldn't be dependent upon the birth seat of your crib, so to say. Thank you so much, Siwa. Then I'd like to continue with Leisl. Leisl, what legal or policy advancements are needed to better recognize and support children as rights holders and agents of change in climate litigation and/or climate advocacy?
Thank you. Great question. Well, looking at the litigation globally and locally, domestic cases, you'll find that young people and children will make the arguments around the rights that you've mentioned, the right to life, but they're not making arguments about special children's rights, as in the right to participate, the right for children's voices to be heard. And we'd like to see more of these in the cases, the principle that the best interest of the child must be paramount in everything that affects the child. And it's, in our opinion, or in my opinion rather, making these arguments will strengthen litigation. And I'm not sure why they don't come up as often as they could. And so one of the aims of our database is to break down the arguments that children are making in different cases across the world, so that if you're making an argument in a different case, you could go there and find the law that you can rely on. So we're really hoping to see the development of these cases at a global level. And there's another hat that I wear here today as an external expert for the African Committee on the Rights of the Child for their climate working group. And so we're waiting also to see what comes from the regional bodies in Africa. And we're hoping that it's not only the right to life, but it's also the right to have one's best interest acknowledged, and the right to participate. We're hoping will develop the law that really recognizes children as autonomous and people with capacity. Yes, thank you.
Thank you so much, Leisl. Speaking of youth and children as rights holders and agents of change, I would like to ask Samira, what exactly is the role of these youth and of broader civil society in this advisory opinion proceeding? And how can people that are currently not a part of it also get involved and also join in on, I won't say join in on the fun, obviously it's join in on the fun, but how can they also help and bring it forward and help and improve on the outcomes of it? Over to you, Samira.
Yeah, I think that the interesting thing with this particular proceeding is that youth and civil society in general have been extremely detrimental in helping it, bring it to this level, actually. Siwa has reminded us the origin story of the case and how it was started by Pacific Youth, and he has been brought up after that to several actually civil societies for support, and an islands of 1,500 civil society organizations have mobilized to show support around this proceeding throughout its build-up. And this alliance has been able then to push states around the world to make sure that this proceeding actually goes to the UNGA and that it gets the vote that it needed. And also, I think that we as World Youth for Climate Justice have been able to actively see how young people across the world in all continents have mobilized themselves to talk to their state and to ask them to vote for this proceeding in particular. And also, we have not done this alone. Joie is here, she's from CIL, and those other NGOs who have also been extremely important in helping to build this case. They have been important to mobilize, as I said, to ask for state to support, but also to provide support to states in explaining how the court actually work and how an advisory work for them, and especially for the Global South, why it's important for them to get involved in this proceeding, but also in helping draft the arguments that they could present to defend their country and their best interests in the courts, but also financially. We think that, when we are talking about states, that they should have like the financial means to be able to access this kind of courts and legal proceedings. But actually, no, some of the states that we are talking with don't have those means. So civil society also have been extremely helpful to make sure that actually, for example, for the oral hearings, states will be able to present in front of the courts. And throughout this whole proceeding and until the end, they have been at the heart of it. To answer the second part of the question on how can people get involved, how can they join the fun, now that we are almost at the end of the proceeding, there's still a lot of things that people can do. We have a petition that has been created by the Pacific Island students, and this petition will be extremely important to be signed. I'll share it in the chat. If you can take 2 minutes of your time to sign this petition and to show the judges at the International Court of Justice that this is important for everybody around the world and that we're looking at what they're doing at the court. You can also try to make a witness stand. A witness stand is basically you starting a video of yourself saying, "Dear judges of the International Court of Justice," and then explaining your story in regard to climate change and how climate change has affected you, because climate change is starting to affect all of us, some more than others, but it is starting. We are starting to see the effects. Me, for example, from Mayotte, each time that I go back, because right now I'm living in France, but each time that I go back, I can see the changes from how Mayotte was in my childhood and how it has changed. Now the coral reef are starting to get bleached more and more. We see less fishes around, and this is disrupting our natural system and our natural, and some of our tradition, for example, there is a tradition where young women and mothers, they go and fish by the corals, and now we can't see this happen anymore. It's a tradition that is starting to disappear. So you can do that, and of course, if you want to know more, please send us an email. I'll put my email in the chat. We are looking for help in several areas, so it will be really amazing to get in touch with people who want to get involved with this proceeding, especially now that we're approaching the hearings. Thank you. Back to you, Mert.
Thank you so much, Samira, for explaining in what way people can be involved. And hopefully we would see a lot of these people on the ground in The Hague, obviously, or online supporting us through various initiatives. And please don't feel any hesitance in reaching out to us. I would love to support you in this. Since our panelists are amazing in keeping the time, I don't need to be a very annoying chair, and we have a lot of time to answer the questions that have been asked by our wonderful audience. I cannot say that I'm also very proud to see more than 300 people in one call. It's amazing. Thank you so much for being here. Nala, how are we doing on the question side?
Thank you very much, Mert. We have a really diverse range of questions today, each of them addressing critical aspects of climate justice and action. And we have three main categories of questions. The first is international climate law and governance, climate justice and equity, and climate action and policy. So let's take a look at the first category. So Ananya from Tanzania asks, how can we differentiate between political power and political will in enforcing climate law? And I'll give you the second question in the same category. Before approaching the ICJ, is it advisable to exhaust local remedies, and should states establish climate and environmental courts?
Thank you, Nala. Two very interesting questions. Who can I give the floor to answer these? I think Neshan, it will be interesting if we could see some of your insights on this.
Thank you, Bert. I'll start off. Thank you, Nala, also for the question and for the people who are asking these questions. On the interface between policy and advocacy and the politics and of climate law. As I think the panel already mentioned, climate change is not only impacting the lives of those who are working on the climate issue, it's impacting every single life form on the earth, not only humans. And I think that's where the evidence where every single member state agreed to put this question to the ICJ is of relevance. And 2 quick points on this. Now we are looking at the developments of laws such as human rights law, climate law, but we also have the International Sustainable Development Law, which has been agreed upon back in Johannesburg through the International Law Association. We have the Sustainable Development Goals that every single member state have signed on to. These are all parts of the international legal framework that emphasizes the political will to change. They cannot be pushed back on this at this stage. And that's why it is so crucial that we capture the imagination of this advisory opinion at this stage. And I keep repeating that is the most important case this century. On the issue on do we have to exhaust domestic remedies on climate before the court to go before the ICJ? No, you do not have to. But it is complementary, as Joie and others were saying. There's over close to 3,000 cases going on, and there will be more cases being petitioned as the ICJ starts its public hearing, and even afterwards. And even after the advisory opinion comes out, I think there'll be more cases that will be filed to make sure that countries implement this. And on the final question, whether there has to be a specific international environment court, yes, this has been a recommendation that has been around for a long time. It was also taken up during the recommendation state of the Summit of the Future, and it is in the outcome document. But also just recall that the International Court of Justice also has a specific environment chamber, and that is within the rules of the court. But that chamber has really not been utilized. That the 15 judges of the court doesn't necessarily have to sit through the whole proceedings, that this environment chamber could take things up. But it's valid to see that right now the compulsory jurisdiction of the International Court of Justice has only been signed up by 74 members of the United Nations. But with all members agreeing to put this question to the ICJ, there is an indirect acknowledgement that the ICJ has jurisdiction over the whole planet. And I'll end with the Capturing Imagination quote that Int'l's advisory opinion talked about sharing and our duties to the 71% of the planet, which is covered by oceans and the seas. The ICJ will look at the whole earth.
Thank you, Neshan. And yeah, I think that's a very powerful statement as well, and also good to reflect on that. I see that Joie wants to come in on this.
Just very briefly on the question of political will and political power. Going back to why this was brought at all, right? These advisory opinion requests before the tribunals and the courts. There's very, very powerful quotes from country heads of small island states before Int'l during the oral hearings, where they talked about how they have for many decades shown up in international spaces in multilateral negotiations, and there has just been complete pushback. There is a pretense as if international law does not matter, that somehow everything needs to be renegotiated from the start. And as we all know, it's heartbreaking sometimes at COPs to see how much political power is there, how much and I'm sorry to use this word, bullying happens of countries that are, might be smaller or does not have as much power. And kind of working behind the scenes on the diplomatic side, you hear like a lot of questions coming up, but this is not the law. Now Paris has come into the room, so human rights law does not matter. The law of state responsibility does not matter. And I cannot emphasize enough that this is not true. This is legally inaccurate. And that is why countries went to the courts and was like, we want a clarification. So at least these conversations can stop. We do not have to live in a bubble where it's as if, this type of legal clarity can help shed light on some of these difficult conversations. And then if you want to break the law, you break the law, but we know that you are breaking the law. So I think that the political power question is very much in the minds of those who have led As I think Siosiua mentioned and Mert mentioned, we've seen so much leadership of global South countries. It is an effort to level the playing field. And then the last thing I'll mention, and I cannot emphasize this enough, there is a narrative shifting and movement building aspect to these types of processes. There is a lot of power, but political will starts to shift when enough people are putting pressure on their governments, being like, we want to see this happen, as the Pacific youth have done, as youth across the world have done, as many people in this call have done. So I think that is really important to take into account as well, to start shifting that political will, which we desperately need to happen.
Thank you so much, Joie. I think that's a very perfect addition to what Neshan also has said. Yeah, I see that more questions are coming in. Nala, asking you for a couple of more questions.
Yes, thank you, Mert. So our second category is about climate justice and equity. So I'm going to give you a few questions together in this category. So Telsina and another anonymous attendee ask, how can we enhance the implementation of effective climate law and policies in developing countries? Our next question is from another anonymous attendee who inquires, do we have international youth climate justice forums to address the needs of present and future generations? And Mark Jarley, a project officer at Green Landscapes Initiatives in Liberia, asks, how can we ensure just energy transition technologies are affordable for impacted communities? Back to you, Mert.
Wow, very interesting, also very technical topics. I see that Samira would like to reply to one of these questions. So is that a hand, Samira?
Yes, I'll maybe answer some of the questions relating to the youth forums and some of the question relating, giving some elements of attention for the question on energy. For the youth forums, I think that it's actually quite easy to find some of those forums. There are so many different ones at all levels in all countries, because I think like young people are really keen on trying to gather together and mobilize and try to think of strategy to make sure that their future is not compromised by the action of either their state or other states living far abroad. So for example, here at COP, you can, if you're interested in joining a youth group, you can try to go towards Yungu, which is a constituency of the UNFCCC, and this constituency specializes in youth question with climate change, and it also can be it has several working groups. For example, there's working group on human rights, if that's what you're interested in just transition, and in ocean, and in all type of categories, depending on what you want to work more on. So there are several kind of mechanisms that try to approach things from a youth perspective. And from the question on just transition and how to make sure that those, I don't remember the exact question, that they are defended, that countries make sure that it's affordable for everyone. I think that there are quite a few elements of answer to that question in international law. For example, within the Paris Agreement, there is under Article 4, a call for just transition. So normally, this article should provide element of answer on how states can make sure that within their country, energy transition is done in a way that is affordable to their citizens. We also have several other elements. For example, if you look at the SDGs, the Sustainable Development Goals, one of the Sustainable Development Goals, like I think it's the 7, also focus on energy, with the aim to make sure that energy is clean, affordable for everybody, and that that there is a universal access to that. And knowing that, for example, for the Sustainable Development Goals, that they work all together, the 17 of them, and there is this Sustainable Development Goal 13 that is on climate action. So those two combined together need to make sure that for people in the future that there is a just transition, but also that is done in a way that is reliable for everyone, and that conduct to resilience. So there are a few frameworks that already exist that need to work around those notions. And if your state is not following some of those international principles, we are starting to see a lot of cases where young people actually go to the court to ask for their state to actually follow the climate actions that they promise at an international level. So looking at litigation could also be one of the solutions to make sure that your state is doing its just transition.
Thank you, Samira. The question about the just energy transition. I mean, I would love to point to someone, but I'm not sure if anyone of our panelists feels inclined to answer that in particular, since it is a very technical question.
I can
is
try.
anyone
If you
comfortable?
like.
Leisl, yeah, please.
I'm based in South Africa. I'm South African, and Samira has just mentioned doing litigation at a local level, and I really like that because you can really localize the issues. And in South Africa, of course, you know, it's an incredibly unequal society, and we are making the arguments in the context of equality and the right to dignity and standards of living. But the stage that we set is the fact that a livable environment and a livable climate is key to living with equality and food and breaking the cycle of inequality, and that courts must continually develop the law towards a just society, and that includes a climate that allows us to live. So we're trying to frame our arguments in that equality sense.
Thank you, Leisl. I'm looking at the time, and I think we have still time for one final question. So, Nala, I give you the honorable task to pick out one final question.
Let's make it two in the same category. So we have
Let's do it.
Questions, climate action and policy. An anonymous attendee asks a very specific question focusing on the practical implementation of climate solutions, and they ask, how can we effectively integrate Article 6.8 on non-market approaches into a just transition? And Eugene is interested in specific context of Africa, asking, what is the current trend of climate change in Africa? And what are the positive and negative impacts?
Thank you, Nala. I think, Siwa, we haven't heard of you. Would you like to come in and answer on and either of these questions?
I can't speak to the African context one. Unfortunately, I wouldn't be the best to comment on that. The initial question, sorry, I broke off just for a bit there, Nala, the first one.
Yes. How can we effectively integrate Article 6.8 on non-market approaches into a just transition?
I would have to revert to the experts on this. I won't begin to pretend that I know that I can comment on this. Apologies for that, Mert.
Thank you, Siwa. I just wanted to offer you the opportunity to also speak on the questions. Joie, Article 6.8, can you enlighten us?
Sure, but I'm not sure in 2 minutes how far we can get. I do think Article 6 is probably my least favorite article in the Paris Agreement. But of that, not super popular because it's very market-based. There are lots of problems in using carbon markets or carbon credits as a way to reduce it rather than focusing on real solutions of reducing fossil fuel and phasing out fossil fuel use over time. Article 6.8 is actually a really good one in that article and the non-ideal scope, because it is non-market mechanisms, it's corporation. So I think very much if we are looking at Article 6, kind of teasing that out and building up the discourse in the negotiation at COP29. So Mert, this is basically a mandate to you. But basically those kind of shifting away from that market approach to really, because as has been mentioned, as Neshan has mentioned, as Leisl has mentioned, Samira, Siosiua, it is about people at the front lines. It is about ecosystems. It is about, I do not think we can continue business as usual and be like, oh, business is going to get us out of it. They have caused this crisis to a large extent, right? So we should be holding corporate actors accountable. Of course, they have a role to play, but we should not just be like, oh, these types of, these types of solutions are where we need to be looking at. We really need to be looking for a just transition for the developed countries to take the lead on, but for all countries to really seriously start thinking about, well, if we phase out fossil fuels, what does that look like? And what is the plan that we have to put into place? The last thing I'll mention is international cooperation. That's really important. That's where we're seeing a breakdown. That's where the geopolitics of today is really gutting to watch. And that's where we have to get back on track and be looking at non-market mechanisms. So I think this is a brilliant question.
Thank you so much. And looking at the time, it's exactly 10 past 12 in local Azerbaijani time. So I would have to end the questions for now. Thank you so much for all the participants for sending in all of these amazing questions. And thank you all for being here as well. I would like to also thank our amazing panelists for their wonderful, wonderful commitment to not only the topic, but also their efforts in the past and in the future that we'll continue to see. So thank you all. Thank you, Neshan, Siwa, Leisl, Joie, and Samira. And thank you, Nala, for moderating the questions. And thank you for all of these 321 participants in this call. I'd like to wish you all a great day, good evening, good night, good morning, and see you all soon. Thank you very much. Have a good one.